to prove any specialty or special characteristic of Chong Choroi security prison. The Defense Counsel indicated under paragraph 43 of the appeal brief that Chong Choroi was another important security center. It indicated that if Dutch were most responsible for the crimes committed under the framework of S21, other security center would have been also charged or prosecuted. However, if it is according to the submission by the co-prosecutors that they had no bound to prosecute all the head of the security center all across the nation, I'm referring to the 195 security prison, then Dutch should be also free. The prosecutors would like to draw your attention to the submission by the Defense Counsel with reference to the prison of the Khmer Rouge prepared by Peng Pung Rasi, who indicated the location of security centers all across democratic Cambodia, and that the defense picked Chong Choroi as the main prison to challenge with the existence of S21. However, these co-prosecutors would like to submit that there is no clear indication regarding the special characteristic of Chong Choroi security prison to prove that it has a different characteristic as opposed to that of S21. According to the document entitled The Chain of Terror, written by Ear Ming III, which really lists the structure of security center of democratic Cambodia. There were five kinds of security centers, including the lowest one, the commune militia office, and then the security centers at district level and sectoral level, and also the zone level. And the highest security center was at S21, which is at the center party. Regarding Chong Choroi, as submitted by the Defense Counsel, it was only the district level security center located in Ro Liep Ia, Kampong Chnang, Sector 31. West Zone. This document is relating to the security center as submitted in the request for additional evidence by the Defense Counsel. The prosecutors would like to submit that this evidence is not new at all. It has already been put in the case file, and the prosecutors have also been familiar with this document already. And that Chong Choroi Security Center could not be used as reference to challenge the ECC jurisdiction over the accused.
Regarding the documents in relation to the biography of 31 people, for this document, as Dutch lawyers requested in the new evidence and accepted by the Supreme Court chamber, the co-prosecutors maintain the same position that these documents already exist in the case file. The 3-page document, although it is not in the case file, and that we are not surprised by this 3-page document. The reason is that we have already known the content that Kang Kek Yew alias Dutch is chief of S21 prison, who worked on the confessions implicated Chakrai Chuk Li Pan in order to conduct the purge, and for the senior people, Pol Pot, Nun Chi and Son Sen, and those subordinates include Ho, Mom Nai, alias Chan, Pon, who executed Goitun, Wonwet Hunam, with his annotation that smashed them to pieces, as in the record of the interview before the co-investigating judges and during the adversary hearing before the trial chamber. We would like to make the observation on the statement raised by Dutch Defense Counsel at the trial chamber. During the hearing on the 1st of April 2009, when asked by the co-prosecutors whether the defense team objects to the personal jurisdiction, the response was no. If I were to raise it, I would have raised it during the initial hearing. So this is just a snapshot for your honors to examine regarding the issue of personal jurisdiction. And right now, before the Supreme Court chamber, the defense would like to reinstate the issue of personal jurisdiction, and that Dutch doesn't fall under the jurisdiction and he shall be released. This submission is contradictory to the content of Article 89 and Article 87 of the internal rules, which in 89 it states preliminary objection in regards to personal jurisdiction shall be raised during the initial hearing, otherwise they cannot be accepted. The additional evidence shall have direct link to the arguments, concrete arguments raised by the trial chamber. Therefore, for the new evidence submitted by the defense team, only the document that is already in the case file and the additional evidence that the defense team submitted, we, the co-prosecutors, would like the Supreme Court chamber to dismiss it, to reject it, and that the Supreme Court chamber shall decide on the personal jurisdiction that Dutch falls within the jurisdiction of the ECCC as stipulated in Article 1 of the ECCC law. I would like to take this opportunity also to make an observation in regard to the transcript of the 1st of April 2009 on page 13 and 14, when the defense team clearly replied, and his reply is in the transcript, that he is not going to raise the issue of preliminary objection on the personal jurisdiction, and that his objection is only to deal with the 1956 Penal Code. The defense team always reiterated that Dutch falls outside the jurisdiction of the ECCC, and that S21 also has a similar hierarchy and status of the other 195 prisons, in particular the Jongchoi prison, and that Dutch shall be acquitted. This interpretation by the defense team cannot be accepted, and we would like, therefore, the Supreme Court chamber to dismiss the appeal by the defense team. I'm obliged, Your Honor. The President, the International Co-Prosecutor, would you like to make a statement or response?
Not at this time, no. Thank you, Mr. President.
The President, I would like now to seek the judges of the bench if you have questions to put regarding this matter.
the co-prosecutors. We need some assistance from you on this, the position taken up by the defense that the senior leaders of the democratic Cambodia and those who are most responsible should be read conjunctively and not disjunctively. The whole basis of the defense argument was on the basis that the appellant is not one of those most responsible. So either Mr. Kelly or Madam Chairling would address court on this, please.
Chilling, thank you, John, for the question. This is an important question in regards to personal jurisdiction. The co-prosecutors would like to respond as follows. We have the view that in Article 1 of the Law on the Establishment of the ECCC, it states that it is to prosecute those for crimes committed during the Democratic Cambodia regime. And there are two categories of people to be prosecuted, that is, the senior leaders and those who were most responsible. We are of the view that in this instance, in particular in this case, we only focused on one of the two categories, that is the most responsible, and we will rely on our discretion to charge people in relation to this group. That is also in consistence with Article 40, and we exercise our discretion is based on the facts and the existing law. We as co-prosecutors can assess the documents we collect during the preliminary investigation so that we can submit it to the convicting judges for further action. And during the preliminary investigation, we considered that Dutch was within the category of those most responsible based on the existing law and facts. And regarding our authority or the discretion to make such a decision, as well as the view formed by the co-investigating judges and the trial chamber in agreement to our decision for the charge against the accused. And with your permission, I would need about 8 minutes to make this short statement, Your Honor.
May I ask the co-prosecutors again, now did the draftsman of the ECCC law and the agreement ever contemplate prosecution of democratic Cambodian leaders who had not been guilty of any culpability? See, if you are saying that the two situations of senior leaders of Cambodia and those most responsible are disjunctive, then what is the culpability that could have been attached to the senior leaders of democratic Cambodia who did nothing between 1975 and 1979?
ខ្ញុំមិញដោយសារខ្ញុំមានការឆ្លើយវាមានពាក់ព័ន្ធទៅនឹងការបកស្រាយទៅលើអ្វីដែលសហ
My response was in the intention to the interpretation
បានសួរនៅថ្ងៃទី23ខែមីនាឆ្នាំ2000
of the question put by Your Honor on the 23rd February.
ថាมันមានចំណងចាំបាច់ត្រូវតែទាំងពីរនោះទេ
Of course, for us, there is no need for us to consider him for the two groups, for the senior leaders or for those most responsible. And of course, these two groups are disjunctive. And I'd like to respond to Your Honor, in particular on the group for those who were most responsible. And also, I would present to you our discretionary power based on the law and the facts to charge Dutch for the crimes committed within the framework of S51. Within the jurisdiction of the ECCC, the co-prosecutors clearly stated, based on the existing law and facts, that Dutch clearly fall within the group of those who were most responsible. The co-prosecutors exercise their discretionary power that Dutch falls within the group of the most responsible, relying on several facts that I would summarize as follows. If you would grant us the time, then I would be able to make a brief presentation. The President, yes, you may proceed. Co-prosecutor. We have reasons to believe that Dutch did commit the crimes within the framework of S21 as chief of the security office. In identifying the persons in our preliminary objection before we send our introductory submission to the co-investigating judges, first we need to exercise our discretionary power to charge, and then we need to assess the facts based on the existing law. We maintain the spirit of Article 1 of the law on the establishment of the ECCC and the spirit of the preamble of the agreement between the United Nations expressing the concerns of the royal government of Cambodia as well as the willing of the Cambodian people to find peace, national reconciliation and peace. In our introductory submission, we considered Dutch as chief of Iceland prison, which is at the central level, and it is at the highest level of the security center offices during the democratic Cambodia regime. The exercise of the discretionary power, as I stated above, we consider the circumstances in which the crimes were committed, and that the charges does not interfere with the peace or stability of the society. The co-prosecutors also consider the views of other international prosecutors, for example, the Special Court in Sierra Leone, that it recognized the necessity to consider the extension of the charges in regard to the stability and political stability in society, and the charges shall not interfere with the national reconciliation and peace within the country. After deciding to open the investigation by the virtue of the introductory submission, with respect to the spirit of the preamble of the agreement between the UN and the government, the co-prosecutors also took into consideration the meaning of Article 1 of the ECCC law which does not require the co-prosecutors to charge all suspects, in particular in the case that was submitted by the defense team for all the security centers throughout the Cambodia, that is 195 to other security centers. The statement is incorrect because the security centers addressed by the defense, including Chong Troi in Relief District Kampong Chnang Province, in the West Zone under the supervision of the Central Zone, based on the decision dated 30 March 1976. In contradictory, S21 is located within the center under the supervision of the Central Committee, and that is based on that decision as I mentioned above. So, it falls under the jurisdiction of the ECCC, and the decision to decide that Dutch falls under the jurisdiction of the ECCC is based on a number of reasons. We not only rely on the international jurisprudence at Sierra Leone, we also consider the specificity at S21, for example, the role and authority, the jure and de facto authority of the accused, for example, his supervision over various sections of S21, as well as the numerous surviving documents. And these documents have already been put in the case file. On the contrary, the defense team did not find any remaining document from the Chong Troi prison. And regarding the exercise of the discretionary power based on the spirit of the ECC law and the preamble of the UN and the government agreement, and based on the other jurisprudence of the Special Court of Sierra Leone, that we, the co-prosecutors, have the power to charge or not to charge any person based on Article 40 of the Code of Criminal Procedure of Cambodia, which clearly states the power to charge or not to charge in the interrogatory submission. Regarding the fact that Dutch falling within the jurisdiction of the ECC also agreed by the co-investigating judges and found to be appropriate by the trial chamber in its judgment. After our initial preliminary investigation, we charged 5 persons in our interrogatory submission for the facts stated in that submission. And after 1 year investigation, that is on the 8th of August 2008, the co-investigating judges issue a closing order or indictment, charging that although Dutch was not a senior leader of the Democratic, Dutch is considered in the category of those who were most responsible for the crimes committed as Dutch. That is, this is the reasoning of the co-investigating judges, that Dutch had the power as the deputy and then as chief of S21, which is under the direct supervision of the Central Committee. And the trial chamber later agreed to the evaluation of the assessment by the co-investigating judges that Dutch falls under the jurisdiction of the ECCC as a person who is most responsible for the crimes committed during 75 to 79. The decision of the convincing judges and the trial chamber that Dutch is the most responsible person and under the jurisdiction of the ECCC is a decision consistent with the discretionary power of the co-prosecutors. These are the reasons based on facts and law applicable and existing law that Dutch fall under the jurisdiction of the ECCC. I thank you, Your Honor. The President, Judge Noguchi, you may proceed.
I have one question to the co-prosecutors. Both parties have been discussing Article 2 of the ECCC law, the expression of senior leaders and those most responsible. Could you provide your understanding as to the nature of these wars? Either these are jurisdictional requirement subject eventually to a judicial review, or these are merely guidance for co-prosecutors in exercising its prosecutorial discretion. Thank you.
ក្នុងការប្រើឆន្ទានុសិទ្ធិរបស់សហប្រញ្ញាក្នុងការចោទប្រកាន់តែប៉ុណ្ណោះសូមអរគុណ
សូមអរគុណលោកចក្រមឲ្យខ្ញុំនឹងឆ្លើយនៅ
Thank you, Your Honor, for your question. I think the issue is not related to the jurisdiction, rather it is related to the competence and the prosecutorial discretion. The President, Judge Millard, you may proceed.
Madam Chialing answered my question. Thank you.
Mr. President, may I add something very briefly? Question that was put by Judge Singer earlier about whether or not this phrase, senior leaders and most responsible, is disjunctive or conjunctive. And I can answer it very briefly, and I certainly support all of the comments that have been made by my learned friend, the National Prosecutor. But if I could refer you, Judge, to paragraphs 27 and 28 of our response to the defence appeal. And that gives insight, I think, into the minds of both the United Nations and also the Cambodian government. Certainly, if one looks at the agreement between the government and the United Nations on one side, and then the domestic legislation passed by the Royal Cambodian government on the other side, you will find that, in fact, the UN group of experts prior to the agreement in 1999 stated very clearly that there were two types of individuals who should be prosecuted, namely senior leaders with responsibility over the abuses, as well as those at lower levels who are directly implicated in the most serious atrocities. Subsequently, in debates in the Royal Cambodian Government Parliament, in the Cambodian Parliament, Deputy Prime Minister Sokhan explained that Article 2 of the proposed law that followed the agreement between the United Nations and the Royal Government allowed the prosecution of two types of targets. One, senior leaders as opposed to persons who held ordinary positions, and two, those who were not the senior leaders but who committed crimes as serious as the senior ones. So I hope that helps you, Your Honour, in your determination of this issue. Thank you.
ថាលោកលោកស្រីចៅក្រមនឹងពិចារណាទៅលើបញ្ហានេះដោយអ្វីដែលខ្ញុំបានបញ្ជាក់នឹងលើកឡើងអំបញ្ញមិញសូមអរគុណ
President, it is now appropriate to have a break. We shall adjourn for half an hour and we shall return at 3:30. Security officer, you can now take the accused back to the waiting room. Graffiti, all rise. Eyes. The President, please be seated. The President, the court is now in session. We will now give the floor to the civil parties council group 3 to make their response.
សូមអរគុណខ្ញុំបាទមេធាវីកឹមមេងខីសាមេធាវីតំណាងដើមបណ្ដឹងរដ្ឋវេនីក្រុម
Thank you, Mr. President. I'm representing civil party group 3. Together with Ms. Martin Jakang, my colleague, we would like to make our response to the statement by the defense on the issue of personal jurisdiction over the accused Kang Kek-yew alias Dutch. After having heard the statements and the response by the co-prosecutors, we are of the view that the defense submission is not based on any legal ground. The victims who are here are not to seek any revenge. Their only wish is to have justice and forms of reparations. One of the observations that we make is that repeatedly the defense team raised the issue of the role and responsibility of the accused in comparison to other prison chiefs, totaling 195 prisons. He is just one of those 190-something prison chiefs. And on the point of law in identifying the suspects who are the most responsible, they raise certain legal grounds, and we are of the view that those certain legal grounds are inappropriate. For instance, the law on the Paris Peace Accord, the law on outlawing the Khmer Rouge, they did not provide any identification of the people within the category of the most responsible persons. Only the ECCC law shall be raised in conjunction with other relevant international jurisprudence. The second point is that the defense team raised the issue of the fact that their client is just one of the many prison chiefs. It is groundless to raise such a matter before this chamber. The assertion that within the party rank is equivalent to a commander of a regime, and that there is no law during the Khmer Rouge regime. If we consider these arguments, if there is no law during the regime, what did they rely on? Of course, they used the law of the wild. It means whoever senior would defeat the lower rank one or the weak one. So the strong ones always beat the weak one. Probably that is the argument raised by the defense team. And another point that the defense raised is that the co-prosecutors only charged one of the many prison chiefs, and the rest of the prison chiefs were not charged. I think that is inappropriate. The charges against this person is the most appropriate. Because if we practice the law of the wild, it means the cows would always, the tigers would always eat the cows and not the cows eat the tigers. And that is clearly stated through his role and responsibility as chief of S21 that he arrested many other senior cadres of the Khmer Rouge. Regarding the details of the legal grounds of our response, I would like to give the floor to my colleague, Ms. Jatin Makang.
Monsieur le Président. Mr. President, Your Honors, Mr. and Madam Co-Prosecutors, Counsel for the Defense, Counsel for the Civil Parties, my fellow colleagues, on behalf of the interest of Civil Party Group 3, it is my honor to answer the Chamber's question asking for all supplementary explanation on the following. Is the language senior leaders of democratic Cambodia and those who are most responsible as indicated in the ECCC agreement and the ECCC law, a jurisdictional requirement that is subject to judicial review? Or is this language a guide to the discretion of the co-prosecutors and co-investigating judges that is not subject to judicial review? Allow me to raise some legal points that have already been raised by other parties, but I hope that we will be able to bring forth new elements and analysis which will allow you for greater contemplation. We wish to recall some of the arguments raised by Duke in his appeal brief with respect to the trial chamber's personal jurisdiction. Indeed, personal jurisdiction is restricted to senior leaders of democratic Cambodia and to those most responsible for the crimes and grave breaches of national and international law. Neither the agreement nor the ECCC law expressly defines senior leaders of democratic Cambodia or those most responsible for the crimes. It cannot be inferred from neither the agreement nor the ECCC law that Gang Gekyu alias Duke is one of those most responsible for the crimes committed. Indeed, the defense claims that the trial chamber considered Duke as forming part of those most responsible for the crimes in order to try him at any cost. The reason why the trial chamber refused to consider Rule 87, as requested by the lawyers for the defense, was because the judges knew fully well that in reality, no elements allowed them to apply Article 1 of the agreement and Articles 1 and 2 new of the ECCC law to Gang Gekyu alias Duke. Accordingly, in the introduction of its judgment, the trial chamber demolished the agreement between the United Nations and the royal government of Cambodia. Indeed, it claims that it violated the fundamental principle enshrined in the common law, principle of legality, by relying on common law authorities for its interpretation of this principle in such a way as to call into question Article 1 of the agreements and Articles 1 and 2 new of the ECCC law, which restrict the personal jurisdiction of the Extraordinary Chamber to senior leaders and those most responsible for the crimes. Had the trial chamber considered the evidence submitted by the defense in their final submission, it would have recognized that it did not have jurisdiction over Gangek-yu, alias Duk. This is indeed why the trial chamber evaded the issue, claiming that the defense preliminary objection was belated. The defense claims that there is a large body of exculpatory evidence adduced by Duke himself. The evidence regards his role and real functions. There was evidence adduced by the prosecution that reveals that the accused is not within the purview of Article 1 of the agreement nor of Articles 1 and 2 of the ECCC law. And unfortunately, the trial chamber omitted to consider that evidence, which amounts to a grave error. This situation arose because in their preliminary investigation, the co-prosecutors did not focus their investigation on the senior leaders who were most responsible for crimes at the S21 Center, but only for the role and functions of Gangek-yu Duk during the period from 17 April 1975 to 6 January 1979. It was precisely this error which led to their mistaken belief that he was among those who were most responsible for the crimes committed at S21, without he or his lawyers being afforded the opportunity to adduce evidence to the contrary. Hence, the co-prosecutors were misled into thinking that the ECCC had jurisdiction to prosecute and try Gangek-yu, since he was to answer for his acts as one of those most responsible for the crimes committed during the DK regime. The co-prosecutors even held the view that he comes under the category of senior leaders of Democratic Cambodia. For their part, the co-investigating judges revisited this conclusion, indicating in their closing order that Gangek-yu could be considered in the category of most responsible for crimes. All of the foregoing elements show irrefutable proof presented by the co-prosecutors and the co-investigating judges by means of precise legal arguments or sufficient evidence that Gangek-yu is within the jurisdiction of the ECCC. Influenced by all of these elements, the trial chamber therefore tried Gangek-yu on the incorrect premise that he came under its jurisdiction. Moreover, it dismissed the defense objections simply on the grounds that they were belated. Defense counsel were apparently not afforded the opportunity from the outset to respond to the co-prosecutors' charges, and the co-prosecutors maintained those charges when they forwarded the case containing the charges against Gangek-yu. They claim that the chamber failed to fulfill the obligation of verifying before accepting to be seized of the case file 001 and whether it had requisite jurisdictional requirements to enable it to exercise personal jurisdiction over Gangek-yu in accordance with the provisions of Article 1 of the agreement, Articles 1 and 2 new of the ECCC law. Moreover, the dissenting opinion of the international judge, reflecting his belief that the trial chamber did not have jurisdiction to try Gangek-yu, amounts to proof that all the trial judges
both national and international, knew and recognized that the ECCC lacked the personal jurisdiction to be seized of case 001. In conclusion, the trial chamber did not have jurisdiction over Geng Yek-il. He held a junior and not senior position, both within the ranks of the government of Democratic Kampuchea and within the Communist Party of Kampuchea. The proceedings in Case File 1 conducted before the trial chamber from 30 March 2009 to 27 November 2009 must be considered as the result of an error by the chamber in the exercise of its personal jurisdiction. I believe that I have summarized the position that has been put forward by the defense with respect to the erroneous characterization. I shall take the care to recall the bench a few provisions as set out in the resolution of the UN General Assembly. I also want to cite verbatim the first article, whose French version leaves absolutely no ambiguity with respect to the definition of senior leaders and most responsible for those crimes. Indeed, Article 1 reads as follows, and I quote, "The purpose of the present agreement is to regulate the cooperation between the United Nations and the Royal Government of Cambodia in bringing to trial senior leaders of Democratic Kampuchea and those who were most responsible for the crimes and serious violations of Cambodian penal law and international humanitarian law and custom and international conventions recognized by Cambodia that were committed during the period from April 17, 1975 to January 6, 1979, full stop." This allows the court to try either senior leaders in a conjunctive manner. The French version of this text does not allow for any doubt to hover. In fact, I regret that my learned colleague from the defense has interpreted the text in his way and has neglected the interpretation of the French text. And I would ask that he revisit his observations made before the bench and refer to the French version of this article. The second article of the agreement refers to the jurisdiction of the ECCC, as it clearly specifies that the extraordinary chambers have personal jurisdiction over senior leaders of Democratic Kampuchea and those who were most responsible for the crimes referred to in Article 1 of the agreement. That very specific article cannot be read differently. It is precisely in this context that the law of 27th November 2004, the law on the establishment of the extraordinary chambers of the courts of Cambodia, duplicates this text. It reads that senior leaders and those most responsible for the crimes committed in Democratic Kampuchea, hereinafter designated as suspects. Once again, in the French version of this agreement, there is no other interpretation that is possible given its wording. The two subjects, the two categories of those who may be tried are those over whom the court has jurisdiction. Very quickly, Article 3 refers to the 1956 Cambodian Criminal Code, Article 4 to the Genocide Convention, Article 5 to the Crimes Against Humanity, Article 6 to grave breaches, Article 7 to the Hague Convention for the Protection of Cultural Property, and I would also call to your attention Article 29, that Defense Counsel was completely silent on. And yet Article 29 is absolutely primordial and would convince anyone that Duke fits into the category of most responsible. It reads as follows, Article 29, any suspect who planned, instigated, ordered, aided, or abetted
and abetted or committed the crimes referred to in Article 3, New 4, 5, 6, 7, and 8 of this law shall be individually responsible for the crime. The position or rank of any suspect shall not relieve such person of criminal responsibility or mitigate punishment. The fact that any of the acts referred to in Articles 3, New 4, 5, 6, 7, and 8 of this law were committed by a subordinate does not relieve the superior of personal criminal responsibility if the superior had effective command and control or authority and control over the subordinate, and the superior knew or had reason to know that the subordinate was about to commit such acts or had done so, and the superior failed to take the necessary and reasonable measures to prevent such acts or to punish the perpetrators. The fact that a suspect acted pursuant to an order of the government of Democratic Cambodia or of a superior shall not relieve the suspect of individual criminal responsibility. It is within this very specific legal context that the co-prosecutors were compelled to research and identify those who fall within the personal jurisdiction of the ECCC. Review of the facts and evidence collected led the co-prosecutors to retain the basis of the charges in accordance with the aforementioned text against Gengekyu alias Duk for his role and functions as chairman of the S21 prison center. It emerged from all of the elements brought together that the accused, contrary to his allegations, was not merely an executor without or bereft of the possibility to express his opinion. Duke was deputy chairman and then chairman of S21. He was appointed by one of the members of the Standing Central Committee during the period in question on account of his experience in managing the detention center M13, where he confirmed his faith in the regime and confirmed his status and qualifications as the best interrogator. His appointment as chairman of S21 cannot relieve him from individual criminal liability for the crimes committed at S21. The accused was actively involved in directing S21. He was a supervisor, he participated in interrogations, he made annotations on confessions by which he gave the party leads and clues on new and potential traitors to search for. He managed the staff members who were entirely under his orders, and he taught them interrogation and torture techniques. Gengekyu had full control over the actions of his subordinates and over everything that happened at S21. He knowingly orchestrated and participated, directly or indirectly, to the elimination of 12,273 people. He supported that policy and the terror methods used. The acts of extreme gravity perpetrated at S21 under his orders constitute crimes against humanity and grave breaches of the Geneva Conventions. The co-investigating judges confirm this characterization upon conclusion of the investigation of the case. The accused and his counsel are therefore wrong to argue that the chamber erred by finding that he was one of the principal perpetrators of the serious crimes committed at S21 from 17th April 1975 to January 6, 1979. It cannot be inferred that this characterization is not firmly grounded in law for the reason that the co-prosecutor's introductory submission characterizes Gengekyu as one of the senior leaders of the government of Democratic Cambodia. The co-investigating judges were bound by the facts and crimes set out in the introductory submission, but they had the discretion to characterize those differently. The argument, therefore, made by the accused does not stand. The assessment of the characterization of the suspect, that is to say, over whom the chamber may exercise personal jurisdiction as defined in the founding legal text of the ECCC, must be subject to a review by the co-prosecutors and an additional review by the co-investigating judges at the end of their investigative action. It is in this context that the trial chamber was seized of the crimes alleged during the period of 17 April 1975 to 6 January 1979 by a person who specifically falls under the personal jurisdiction of the chamber as provided for in the founding text of the ECCC, and that person is Duke.
However, the chamber, seized of the charges made against a suspect, such as Duke, cannot content itself solely on the terms of its saisine. It is within its jurisdiction to consider the facts and evidence that are brought before it and verify if, effectively, it may exercise its jurisdiction based on the same facts and its jurisdiction over the suspect, in this case, Duke. Effectively, the answer that we submit to the question you put before us is as follows. Indeed, the definition of the term senior leaders of democratic Cambodia and those most responsible for the crimes mentioned in the law on the ECCC constitutes a jurisdictional requirement that is subject to prior judicial review by the co-prosecutors and the co-investigating judges. But yes, the Chamber does hold the discretion to proceed with recharacterization. In fact, the Chamber was entirely aware of this imperative and proceeded with a minute and detailed examination of the facts, charges, and evidence regarding the accused for the purpose of delineating the contours of its personal jurisdiction. The Chamber has, moreover, addressed this observation. Indeed, the Chamber examined each of the crimes that the accused is charged with and explicitly recalled under Section 2.5.2.5 that the evidence satisfies the Chamber that S-21 was an integral part of the CPK political and military structure and was considered vital to achieving the party's political objectives. It implemented CPK policies such as the smashing of CPK enemies. The accused's role as chairman of S-21, reporting directly to members of the Standing Committee, gave him a unique vantage point from which to implement this policy. The Chamber infers that he was aware of the points from which to implement this policy, and that S-21 was an important component in implementing it. The Chamber recalled that the co-investigating judges did not allege that the accused was a senior leader of democratic Cambodia, but instead charged him as being one of those most responsible for offenses committed during the temporal jurisdiction of the extraordinary chambers. The Chamber recalled the dispositions of the closing order, according to which it was said Duke was not a senior leader of democratic Cambodia. He may be considered in the category of most responsible for crimes considered during the period in question, due both to his formal and effective hierarchical authority and his personal participation as Deputy Secretary, then Secretary of S-21, a security center which was directly controlled by the Central Committee. Neither the agreement concerning the ECCC nor the law on the establishment of the ECCC expressly defines quote-unquote senior leaders of democratic Cambodia or those who are most responsible for the crimes committed. However, the group of experts on Cambodia, struck in 1998 by way of a UN General Assembly resolution, accordingly recommended that any tribunal focus upon those persons most responsible for the most serious violations of human rights during the reign of democratic Cambodia. This would include senior leaders with responsibility over these abuses as well as those at lower levels who were directly implicated in the most serious atrocities. The jurisprudence of other international tribunals, which have also examined the notion of most senior leaders suspected of being most responsible, have considered both the gravity of the crimes charged and the level of responsibility of the accused. It was drawn throughout the hearing that the accused had participated in the training of the interrogation methods as well as took part in the planning of the center's activities. As chairman of S-21, he supervised the overall functioning of the center by specifically making annotations on the confessions of the detainees and ordered execution. S-21 was an important security center in democratic Cambodia. It was considered the organ of the Communist Party of Cambodia. Its leadership reported to the highest echelons of the party. It conducted activities on a countrywide scale, and high-ranking officials and notable prisoners were incarcerated there. More than 12,000 people were detained at S-21, a figure
or toll that remains incomplete because the practice at the prison was not to register all prisoners. Victims from all over Cambodia were sent to S21. This is what enabled the prison to spread its scope of activity throughout the entire country. S21 operated from October 1975 to the start of 1979. Throughout the entire time, DK existed. As such, the Chamber agreed with the conclusions drawn by the co-investigating judges and believes that in his capacity as one of the senior leaders of crimes and serious violations of Cambodian and international law committed during the period from 17 April 1975 to 6 January 1979, the accused is within the personal jurisdiction of the ECCC. It is therefore necessary for the Chamber to determine if the accused was one of the senior leaders. As such, upon review of the aforementioned documents, it may be concluded that the co-prosecutors, during the initial stages of the proceedings, had focused on the issue as to whether Gengkyu could be defined as one of the senior leaders or most responsible. Secondly, that the co-investigating judges had asked themselves the same questions and partially amended the preliminary conclusions of the co-prosecutors. And thirdly, that the trial chamber had also specifically asked the same question and answered in the affirmative. I now wish to make a few remarks with respect to procedure.
We wish to remind that pursuant to the agreement, the extraordinary chambers exercised and once created, the ECCC issued their internal rules. The internal rules has the object of consolidating applicable Cambodian procedure that is applicable before this court. The agreement provides, as well as the law on ECCC provides, that reference may be made to extra rules when the rules in effect do not deal with a specific question, or in case of uncertainty regarding their interpretation, or if the question is raised regarding their compatibility with international standards. But the internal rules is very clear on this point. Cambodian law before the trial chamber and international rules of procedure may also be used as a reference in case of need. In the context of the difficulty presented by the issue, the preliminary objection raised by the accused, there is nothing to challenge because Rule 89 is perfectly clear. All
I now wish to make a few remarks with respect to procedure.
We wish to remind that pursuant to the agreement, the extraordinary chambers exercised and once created, the ECCC issued their internal rules. The internal rules has the object of consolidating applicable Cambodian procedure that is applicable before this court. The agreement provides, as well as the law on ECCC provides, that reference may be made to extra rules when the rules in effect do not deal with a specific question, or in case of uncertainty regarding their interpretation, or if the question is raised regarding their compatibility with international standards. But the internal rules is very clear on this point. Cambodian law before the trial chamber and international rules of procedure may also be used as a reference in case of need. In the context of the difficulty presented by the issue, the preliminary objection raised by the accused, there is nothing to challenge because Rule 89 is perfectly clear. All questions regarding the Chamber's jurisdiction are considered and all these preliminary objections had to be, under the penalty of inadmissibility, be presented at the latest within 30 days following the date when the closing order became definite. The accused and his counsel did not use this possibility. Thus, we say in French, it was too late. When the initial hearing took place, the accused made a few observations, and these observations never focused on the Chamber's jurisdiction, and it is only when this trial began, which lasted 9 months, that the defense suddenly raised this issue and argued on this problem
in order to try to demonstrate that from the beginning the chamber did not have the jurisdiction to try the accused because he was not a senior leader, and challenged that he was one of those most responsible for the crimes committed. The chamber considered that this late submission could not constitute a regular preliminary objection. In the same way, the defense's arguments, according to which, pursuant to Annex 5 of the 1981 Paris Agreement and of the law outlawing the members of Democratic Cambodia from 1994, that the accused could not be prosecuted for the crimes charged. And these arguments were also presented in a belated fashion, and thus were also rejected. And we would like to remind as well that during the first substantive hearing of 30 March 2009, a full reading was given by the co-prosecutors of the indictment, and Duke, who was present during this hearing with his counsel, point by point accepted the vast majority of the charges despite their gravity, and did not and only challenged a few details that seems maybe secondary, or let's say very limited in relation to all of the charges. But pursuant to Rule 87 of the internal rules, subparagraph 6, it is expressly provided that when the co-prosecutors and the accused agree that there is nothing to challenge in the indictment, that the chamber can consider that these facts are proven. That is to say that following this first day of hearings, following this full reading of the indictment, following this acknowledgement to more than 80% of the facts in this indictment, well, the chamber established the evidence that proved the facts in a proper manner. So in this context, the accused and his counsel never challenged that the ECCC had jurisdiction vis-à-vis him, nor that he was part of those most responsible for the crimes that were committed under Democratic Cambodia due to the facts that are charged. Thus, the lack of jurisdiction of the chamber was neither raised formally nor in a regular manner by the accused in regard to the internal rules, or in limine litis, and this is thus pursuant to Cambodian rule and pursuant to international humanitarian custom law to which Cambodia abides, that the chamber deemed that it was seized on a regular basis and considered that the facts held against Duch proved the personal jurisdiction of the court, and thus allowed the court to sentence him. Thus, and in the interest of the civil parties, we kindly are requesting you to confirm the judgment that was handed down by the trial chamber on 26 July 2010 in the fact that it re-examined the terms of its personal jurisdiction and retained Duke as being part of the category of the suspects, and whose judgment falls under the agreement as well as the ECCC law. And it is in this context that we will confirm that Duke was falls indeed under the personal jurisdiction of the court. Thank you.
The President, Defense Counsel may reply, should they wish to do so. I mean, they reply both to the co-prosecutors and the civil party lawyers. Counsel thank you, Mr. President. I would like to reply to the response made by the co-prosecutors. First, the prosecutors indicated that Duch acknowledged the crimes committed at S-21, and that such acknowledgement proves that Duch falls under the personal jurisdiction of the ECCC. Allow me to emphasize that Dutch acknowledged the crimes committed at S21 even when he was before the military court. He did not contest it. But the question here is who is the main author of the crimes? It was those people who had the right to make the decisions and orders, and that Dutch did not enjoy such right. He received orders from Son Sen and Nuon Chea. Point number 2, the co-prosecutors indicated that the Defense Counsel raised the matter of preliminary objection, which is contradictory to the facts and the law at issue. Allow me to respond that judgment paragraphs 15 and 14 indicated that clearly that the matter raised then was not the issue of preliminary objection. In short, third, the co-prosecutor said that Dutch falls under the jurisdiction, personal jurisdiction of the ECCC, while the Defense Counsel challenged. I would like to draw your attention to Penal Code Article 24, which indicates that each individual shall be liable for his own crime. And these crimes were not committed by the accused himself. In the final submission of the co-prosecutors, paragraphs 15 and 11 and 10 of the indictment or closing order indicated further that the Communist Party of Cambodia issued the orders, not Dutch himself. So those who issued orders must or shall be accountable for the crimes. While Dutch only received order, he shall not be liable for the crimes. Number 4, the prosecutors indicated that the lawyer, the defense counsel, failed to request that the co-investigating judges summon Nuon Chea for questioning. I would like to show this piece of evidence that Mark Salomon, the co-investigating judge, and Mrs. Anna Austin advised or ordered the judicial police, Mr. Beston, to only investigate inculpatory evidence and that not exculpatory evidence. Of course, this task must be vested with the co-investigating judges to do so, but they failed to do it. Dutch was not really the senior person. Even his superior was not really holding the highest position. On top of him, there were more than 7 people. When Son Sen went to the battlefield, Nuon Chea was Son Sen's successor, and Nuon Chea was already stated in Dutch's testimony that he was the chairman or the superior of Dutch. And Nuon Chea himself was not summoned to the hearing. So why should this be the role or the task of the defense counsel to do so? Why not the task of the judges? Point number 5. Everyone is quite familiar already that the democratic Cambodia is a lawless regime. Since the regime is lawless, whatever any individual did was not against the law. How could it be against the law if there was no such law? Number 6. The prosecutor indicated that the defense counsel referred to the law on the outlawing of the Khmer Rouge group. I would like to make it clear that we did not really make such assertion. We only refer to the ECC law. the co-prosecutors are those who really protect the law, not the defense counsel. Defense counsel are those who enforce the law or implement the law. The Article 129 of the law states that the proceedings, the trial proceeding must be in accordance with the existing law. And the law outlawing the Khmer Rouge is still in force, and we would like to appeal to the co-prosecutor not to violate the Constitution, Article 129. 7. The prosecutor indicated that S21 Security Center was the central security center, while Chong Chroy Security Center was very small at the district level. But I would like to draw the Supreme Court chamber attention regarding how many people killed in that Chong Chroy Security Center. You called it a small security center where more than a lot of people were killed. More people even were killed at Chong Chroy than at S21. Why such a security center and chief officers, that security center did not fall within under the jurisdiction of the ECCC? And the law really requires that individuals are liable for the crimes they have committed, because there are mens rea and actus rea, and that the institution was supreme. The law states that only the senior leaders and those who fall under the personal jurisdiction of the court shall be prosecuted, and that the chiefs of security center of Chong Chroy and S21 were not those who shall be prosecuted under the personal jurisdiction of this ECCC. Point number 8, the prosecutors indicated that the defense counsel during the trial proceeding indicated that we did not challenge the jurisdiction of the ECCC. Now, I would like to make it clear that we are not challenging the jurisdiction of the ECCC. Again, loud and clear, because the ECC has jurisdiction to bring to justice those senior leaders and those who were most responsible for the crimes committed during that regime. But what we are challenging is the methods employed by the prosecutors before the trial chamber to put Deutsche as or presume that Deutsche was the senior, the most person responsible for the crimes for the purpose of these trials. Point number 9. The co-prosecutors indicated that they have the right, according to Article 40 of the Penal Code. Of course, I fully concur with them that this right should be well enjoyed by the prosecutors. But here at this tribunal, Article 5, subparagraph 3, and Article 6, subparagraph C of the agreement of the ECCC set the scope of investigation and the prosecution to be maneuvered by co-investigating judges and prosecutors. So this scope has been well set. It doesn't mean that co-prosecutors or investigating judges can do whatever they wish. Otherwise, it cannot be accepted. They have to really exercise their power within the confined and limit the set rule. In relation to the civil party, who indicated that during that time there was no law, but I think they did not really fully cite our submission, I did say further that at that time there was only political line, only the policy by the Angka that no one could not contest. Who could contest such policy or line? For example, Dutch was at S21 when Won Wet, who was his former superior, was sent in. That person must had to be smashed. Dutch himself could not intervene because the regime already said so, that the person had to be smashed. The line did direct everyone to really follow it. And I think that is all from me. I would like to share the floor with my co-counsel. Mr. Kong Ratiri, thank you, Mr. President, for allowing me the floor to add further on top of what my colleague has just indicated. The co-prosecutors used a lot of terms in relation to the charges brought against Kang Kek Eo, alias Dutch, and that Dutch falls under the jurisdiction under this ECC by its discretion. The use of discretion without any reference to the facts or evidence or standard constitutes to a violation to Article 13 of Geneva Convention of the 12th of August 1949 in relation to the right, civil and political right when it comes to due process. Article of the Criminal Procedural Code of Cambodia, which prohibits strongly the interpretation of the laws by means of analogy. So any application of jurisprudence by international tribunals are erroneous, and that the Defense Counsel requests that such assertion be rejected. Regarding the internal smash, the defense support the idea that it is true, and because the function of smashing the internal people or people in the party rank means that only people who were in the rank would be affected, not other victims. And S21 was tasked with smashing the enemy of the state. Anyone who would like to challenge the party would be smashed. So other than that, there are only about 5 to 10% of the people who were innocent prisoners. Among the many prisons, I would like to only raise 9 prisons where more people were executed. For example, like at one prison, 10 times a number of prisoners were executed. At, for example, Chong Chroy, more than 100,000 prisoners were killed. Prison Po Tunle in Kandal, 350,000. Wat O Trakuon, Kampong Cham, more than 320,000. Wat Kampong Tralaj, Kampot, more than 210,000 people. Wat Takau, Bati, and Wat Barai, Kampung Thum, more than 100,000. Takau, Borai, Julasa, more than 150,000 to 200,000 people were killed. But at S21 or Tuol Slang in Phnom Penh, Dong Kao, only 1,400 people to 150 people were killed. And those who were killed at S21 were only soldiers who were perceived as enemies of the state. And there were two main groups of people who were killed, the enemy of the Angka and the enemies of class. Civilians, I mean, who were accused as enemy. They were former officials or capitalists or feudalists, and in particular the 17th April people, as they call. S21 had scope over the whole country, but individual scope was limited. And the other prisons that I mentioned had bigger scope of coverage than S21 when it comes to the broad term. The prosecutor indicated that they maintain their discretion to interpret how to define people under the jurisdiction. And however, they fail to refer to any law in relation to this particular assertion. Among the many senior leaders of the Khmer Rouge, some people were not involved in the crimes, and this assertion can be found in the preamble of the report presented to the General Assembly of the United Nations. And only those who were responsible for the crimes were regarded as senior leaders. So the people who committed the crimes, and I think the prosecutor have made a mistake in defining these terms. That's why it has given rise to the full submission of documents before or evidence before the court. The ECCC determination on the personal jurisdiction does not heavily rely on just the evidence submitted by the co-prosecutors. They, at the same time, need to look at the personal jurisdiction and the jurisdiction over the offences, because the chamber is vested with the power to review these on its own. For example, to which group of people shall be prosecuted and to which group shall not. And the defense would like to challenge the assertion by the prosecutor regarding this, and that when it comes to our submission concerning the preliminary objection, because we had to really submit the submission rather late in the proceedings, because more evidence have been located, and that our assertion or arguments have to refer to the evidence according to Rule 87 of the internal rule, because the rule states that evidence can be submitted by the parties at any time during the proceeding, and that reference to Rule 89 to reject Rule 87 is not proper. I would like to admit that S21 was the central prison, and Deutsche never contest such assertion, because he was convinced that this prison was the prison of the center and the military prison. It used to be under the supervision of Division 703, who was chaired by In-Lawn alias Nat, who ended up being the victim of S21. Because the prison was the central prison, that's why central people were overseeing this. For example, they have the people from the party's line and the government line, people including Pong and Lin, who oversaw another prison at Wat Butum. At Wat Butum was the place where people who challenged Pol Pot personally directly were kept and smashed. And from the border party's line, for example, there was Pong and members from the standing committee. And from the government, there were a committee of the central military. And I think the information has already been indicated in the case file, and also the general staff of the army, which was chaired by Son Sen. There were a lot of divisions and division commanders, including Mut Sumet and other people. Son Sen really oversaw directly this prison, and when Nuon Chia succeeded Son Sen, Nuon Chia exercised the power to control S21. We agree that for prosecutors, it's 50% correct when they indicated that S21 was a central military central prison. Other prisons. We agree with the co-prosecutors that those prisons at the zone were independent and that their function was lower. But I think we challenge such a assertion because at S21, the head of S21 could not really interfere in the affair of other prisons. When report was made from zones, prisons, they were sent directly to Pol Pot, not to S21. That's why Pol Pot ordered such arrest, and that ordered Son Sen to arrest those people. We noted that that's why that's why some prisoners were brought in from the zones. Dodge indicated that he never received any prisoner from the west, the southwest zone, because Tamok was the head of that zone, secretary of that zone, and he was in control of the prison there. And you may also be familiar with the southwest zone, the chairman of which was very cruel. And the prosecutors also submitted evidence concerning the secret decision by the DK of 30th of March 1976. We are not suspicious in relation to who are bound by Articles 1 and 2 of the ECC law. I would like to end this submission regarding the prosecutor's response. I would like now to proceed to the reply to the civil party lawyers.
I completely reject the assertions by the Civil Parties Council. This is contradictory to the ECC law in paragraph 3. Because civil action and criminal actions are two separate actions. The criminal action is to find the guilt of the accused and to punish accordingly, and the civil action is to find the harms committed upon the person or the victims and to seek reparations proportionate to the harms they suffered. It means the civil party lawyers could only seek reparation for the civil part of the judgment. So whatever the assertions are, I completely reject it. Only the co-prosecutors can make assertions on the criminal actions. So this is not the obligation of the lawyers for the civil parties to assert on the issue of personal jurisdiction of my client Dutch. The President, it is now time appropriate for the adjournment for today. And the court will adjourn and will resume tomorrow morning, the 29th, at 9 a.m. Security guard, you are instructed to bring the accused back to the detention center and bring him back tomorrow morning at 9 a.m. The court is now adjourned. The graphic, all rise.